This week, the Supreme Court will wrap up its term as we await several potentially landmark opinions on topics from same-sex marriage to affirmative action. It's all coming down to the wire. Here now with their insights, Carrie Severino, Chief Counsel for the Judicial Crisis Network, and Elizabeth Wydra, Chief Counsel for the Constitutional Accountability Center. Welcome to you both.
Thanks, Shannon.
I got to ask you both, are you surprised that this level of high-profile cases is left at this point?
Well, it takes a long time to write these big opinions, and I think, the court in all of these cases, the affirmative action case, marriage equality, voting rights, is dealing with the meaning of equality in the Constitution across all of these cases. That is the big issue. And so the court, what I'll be looking for is whether the court articulates a coherent vision of equality in the Constitution, remaining true to the text and history of the 14th Amendment's Equal Protection Clause, which guarantees in broad terms equality of rights for all, including the civil right for marriage, to very broad language. It guarantees this equality to any person that's black or white, straight or gay, immigrant or citizen.
Well, and you mentioned the same-sex marriage case. There are two of them, obviously, one dealing with a state measure, one with dealing with a federal measure. And they have gotten the most attention probably this term. But as we await to see what the court's going to do, there's a lot of attention being placed on some remarks by Justice Antonin Scalia speaking at a function this week, saying that the justices can't be moral arbiters. They aren't religious leaders. And so they should leave this to the public, not specifically mentioning this case because he can't say anything while it's still pending, but saying that tough decisions of a moral nature should be left to the American people. What does that suggest to you, Carrie?
Well, again, I think certainly the meaning of equality is an issue here, but there's a real question of who gets to decide on these tough questions, and that's what a lot of these cases touch on. Certainly we see that in the Prop 8 case. Can the citizens of California decide to define marriage within their state? In the Defense of Marriage Act, the same thing for the federal government. Does the federal government have the authority to define marriage? Why would they not have that authority for the sake of their own laws? And can the American people, through their democratically elected representatives, do that? So I think that's what the court's going to be doing. Does the court take that away from the people and their representatives, or do they let this play out in the political process? For really contentious issues like we're seeing here, I think history shows us that those should be worked out through the political process and not courts really usurping that from the people.
We do see a number of states moving forward, approving of same-sex marriage and changing in that respect. And so we'll see whether the justices allow that to continue at the state level or elsewhere. But it's interesting that in both these same-sex marriage cases, it's possible they don't get to the merits. There are these wonky procedural and technical issues. How disappointing do you think it will be to both sides of this argument if they don't actually go to the merits, if they do something much more conservative?
Well, I think it will certainly be disappointing to the families and couples who want their marriages to be recognized as just as good as anyone else's marriage. The bans on marriage equality really place a badge of second-class citizenship on gay and lesbian couples, their relationships and their families, and the Constitution prohibits that. And so I think if the court doesn't actually step up and decide the merits of this case, then that's a real disappointment because the Constitution takes certain issues out of the democratic process. The Constitution says, no, this is so important that we are declaring equality for all persons in the Constitution. And the court held that just about 40-some years ago when it struck down bans on interracial marriage, and it should do so again for gay and lesbian couples who want that same recognition and to which they are entitled that same recognition under the Constitution.
Carrie, is this case different?
Well, the question is really whether the Constitution did do that. In 1868, is that what the 14th Amendment meant, that marriage between a man and a woman is actually not correct, that we have to have marriage between anyone who wants to get married? I think that's a pretty long shot thing to say that in 1868 that was what the Constitution was amended to say. In fact, that amendment was talking about race, and I think that's absolutely clear. Whether our country wants to take it another step and change the definition of marriage, that's something that the political process has to work out. We could certainly have another amendment go through to talk about that. That's not what the 14th Amendment said. And I think our Constitution also talks about which kind of cases the court can decide. The issues here, of the procedural issues, are pretty sticky, and it might just be that these particular cases that have been brought up aren't ones that the court is able to decide, although that would be frustrating for everyone after the time and the effort that's gone into these opinions.
All right, super quick, because you're both excellent lawyers and have a lot to say, but super quick, I want to mention the affirmative action case, which deals with whether a school can use race in an admissions policy. This involves the University of Texas at Austin. So I have to quickly ask you, this case was heard in October. It is still outstanding, suggesting to us the justices are really struggling with this. Do you think ultimately race in some way will or won't be allowed in admissions policies?
Well, I think if the court follows the text and history of the 14th Amendment, they'll allow University of Texas's policy to go through. You know,
including the use of race.
Including the use of race. The drafters of the 14th Amendment were the originators of affirmative action. Just after they passed the 14th Amendment, they also passed programs that were included, that were intended to allow increased opportunity to African Americans in particular, and they rejected arguments that this race-conscious measure was somehow violative of the Constitution. And they also expressly wanted the Equal Protection Clause to go beyond race. They specifically rejected proposals for language of the 14th Amendment that would just have limited it to race discrimination.
I got to cut you off so I can give a quick sentence here to Carrie.
As Chief Justice Roberts wrote a couple years ago, the best way to stop discrimination on the basis of race is to stop discriminating on the basis of race. We need to have colorblind admissions policies, and that's how we're going to affect the meaning of the Equal Protection Clause, truly equal before the law.
Within days, we should have answers to all these questions. Thank you both very much.
Thank you, Shannon.
All right,